Trespass to Land. Introduction. Trespass to land is one of the oldest torts under common law. It protects a person's right to exclusive possession of land. Any direct and unlawful interference with land without lawful justification amounts to trespass. Actual damage is not necessary to prove trespass. The law treats trespass seriously to safeguard property rights. This topic is very important for LLB examinations. Meaning of trespass to land. Trespass to land means an unjustifiable intrusion by a person upon land in possession of another. The intrusion may be by entering upon land, remaining on land, or placing objects on land without permission. Trespass may be committed intentionally or negligently. Even innocent entry without authority amounts to trespass. Lawful possession, not ownership, is the basis of this tort. Essential elements of trespass to land. For trespass to land, the following elements must be present. The plaintiff must be in possession of the land. There must be direct physical interference. The interference must be without lawful justification. No proof of actual damage is required. Motive or intention is generally irrelevant. Forms of trespass to land. Trespass to land may occur in the following ways. Entering upon land without permission. Remaining on land after permission is withdrawn. Placing objects on another's land. Causing a thing or third person to enter land. Possession is the basis of trespass. Only a person in lawful possession of land can sue for trespass. Ownership without possession is not sufficient. Possession includes control and intention to possess. Even a wrongful possessor can sue against a stranger. This principle protects peace and order in property relations. Case law, Graham v. Peet, 1801. Facts: the plaintiff was in possession of land but was not the owner. The defendant entered the land claiming ownership rights and disturbed possession. Held: the court held that possession is sufficient to maintain an action for trespass. A person in possession can sue anyone except the true owner. Trespass is actionable per se. Trespass to land is actionable without proof of actual damage. The law presumes injury once unlawful entry is proved. This rule exists to protect possession itself. Even trivial or harmless entry amounts to trespass. Compensation may be nominal where no damage is shown. Case law, Intick v. Carrington, 1765. Facts: government officers forcibly entered the plaintiff's house without lawful authority and searched the premises. No physical damage was caused to property. Held: the court held that the entry was unlawful and amounted to trespass. Trespass is actionable per se, and legal authority is required for entry. Continuing trespass. Trespass may be continuing when the defendant unlawfully remains on land or allows objects to remain on land. Each day of continuance gives rise to a fresh cause of action. Damages may be claimed for the entire period. An injunction may also be granted to stop continuing trespass. Case law, Holmes v. Wilson, 1839. Facts: the defendant built buttresses that extended into the plaintiff's land. The structures remained permanently on the land without permission. Held: the court held that the act amounted to continuing trespass. The plaintiff was entitled to damages and removal of the obstruction. Defenses to trespass to land. Common defenses include consent of the plaintiff, legal authority, necessity, private defense, entry for lawful purpose, remedies for trespass to land. The remedies available are damages, injunction, recovery of possession. Conclusion. Trespass to land protects the right of possession and ensures that no one interferes unlawfully with another's property. The law treats trespass as a serious wrong even without proof of damage. By providing remedies like damages and injunctions, tort law ensures effective protection of property rights. Trespass to land is a fundamental topic for LLB examinations and practical legal understanding.